may be seated. All right, let's get back on the record at this time. We've had some discussions off the record, most of which we need to deal with on the record at this time. First of all, I'd like to deal with the proposed jury instructions for the sentencing phase. The court did provide draft copies to counsel, I think, last Friday, and we've had some discussion this morning. So first of all, with respect to the changes that I had indicated to counsel when I provided the draft, I think those were minimal changes from recommend to return a verdict and some other language that was deleted. Any objections on behalf of the state with respect to those?
No, all those were acceptable to the state.
Okay. On behalf of the defendant?
No objection.
Okay. All right. Then as to the discussions that we had, court is referencing right now page 4. Language was added. A defendant has the burden to go forward with evidence of mitigating factors and to prove their existence by a preponderance of the evidence. Preponderance of the evidence is the greater weight of the evidence. That is, evidence that you believe because it outweighs in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. That language was added on behalf of the state with respect to that language.
Yes, Your Honor, I think the court had previously, pursuant to a motion the state filed, agreed that that was a proper instruction and issued a written decision on it. In the state's first draft, I didn't neglected to include it. And the court then, when I noticed that, did include it on page 4 under burden of proof, and I understood the defense did not object.
Okay. All right, Mr. Thomas?
Judge, contrary to what Mr. Brown indicated in this case, I would stick by whatever ruling that the court made previous in terms of his arguments as far as the preponderance of evidence.
Okay.
So whatever I did at that particular hearing on that motion, I would stick by it.
Okay. The court will accept that.
I think for the record, they did object at that time, Your Honor, and the court, I think, issued a written decision.
Yeah, I think the record should reflect the defense's objection to including the language initially, but the court had issued a decision indicating that it was inclined to include the preponderance of the evidence language. Okay. On page 9 of the proposed instructions, and looking at 2929.04 B, it outlines the mitigating factors that can be considered. What the court has done is included all the mitigating factors so that we should have, in your proposed instructions, 1 through 9. The initial draft only included 1, 2, 3, and 9. 4, 5, 6, 7, and 8 were added by the court after our discussions this morning. All right, so on behalf of the state.
Yes, Your Honor, and I think so. The record's clear. 4 through 8 were added at the defense request after the court indicated that you were going to include number 1, the nature and circumstances of the offense. And at that point, the defense said, well, if you're going to include number 1, overall objection, we would ask that all the statutory mitigating factors be included. And the state has no objection if the court gives it as submitted on page 9.
All right, thank you. On behalf of the defendant.
Thank you very much, Your Honor. Judge, in the original, I believe, on page 9, defense took issue with the listing of the particular, number one, the nature and circumstance of the offense. It was the defense's position, and still remains, that only mitigating factors that can be argued in this case are mitigating factors that the defense presents. And if we chose not to present any mitigating factor, even though it's listed statutorily as mitigating factors that we can produce, and I believe the court, Mr. O'Brien said that 2904 indicates that there were certain factors that shall be included, we would still object to that and would argue to the court that the only mitigating factors that can be argued and presented in this case are the ones that we present. And we understand the language of the statute says that those nature and circumstances are presented so that the jurors can determine if there are any mitigating factors coming out of those. So that's why we objected, because we feel that the nature and circumstances of the offense in this particular case are not mitigating factors that we want to discuss. So that's what we asked the court for. I think the court's ruling on that was that that objection would be overruled and that information would be presented. And at that point, we indicate to the court that if the court was going to allow that to be in, we request that all the mitigating factors listed by the statute would also be included in the jury instructions.
Okay, thank you. Yeah, the discussions that we had in the back, the court indicated, looking again at 2929.04B, I believe it's the very last sentence, and I'll read it in part. The court, trial, jury, or panel of 3 judges shall consider and weigh against the aggravating circumstances to prove beyond a reasonable doubt the nature and circumstances of the offense, the history, character, and background of the offender, and all of the following factors, which lists the factors 1 through 7. The court had indicated that at a minimum, the court was going to include the nature and circumstances of the offense, the history, character, and background of the offender. And when the court indicated that, the defense asked the court to include all mitigating factors, which are now included within the jury instructions. Hopefully that fairly summarizes our discussions.
On behalf of Mr. Parker, it does, Your Honor.
Okay. And actually, one more specific change that was added on page 9, the sentence next to the last paragraph, last sentence, under the law, mercy is not a mitigating factor and should not be part of your consideration. And no objection by the state.
No, Your Honor, the state noticed that absence of that sentence and asked the court to include it, and I think the court agreed to. The defense indicated it did not have an objection to its conclusion.
Thank you. On behalf of the defendant, that sentence.
Judge, I just know my reading of all the opinions that have been handed down in terms of the issue of mercy. The courts have ruled that that is not a independent mitigating factor. And so I think that this is a proper statement of law.
Okay, thank you. Okay, any other objections or any additional information that either side wishes to place in the record as it relates to the jury instructions?
Not from the state as to jury instructions for the sentencing phase. I think the court also forwarded copies of a preliminary instruction that the court was going to give, and with the inclusion of an explanation about the first specification on counts 1, 3, 5, 7, and 9, the state did not object to any of the preliminary instructions.
Okay. All right, we'll get to that in a second. But as to the proposed jury instructions, anything else on the record on behalf of the defendant?
No.
All right, thank you. All right, yeah, the court did indicate that it's going to provide preliminary instructions to the jurors. As part of the preliminary instruction to the jurors, the court is going to read, there is an additional aggravating circumstance for your consideration, which was found by the court. This is specification 1 to counts 1, 3, 5, 7, and 9. The additional aggravating circumstance found by the court is that prior to the offense in this case, Anthony Pardon was convicted of an offense, an essential element of which was the purposeful killing of or attempt to kill another person. Is that the language that you were referencing, Mr. O'Brien?
Yes, Your Honor.
Okay, all right. On behalf of the defendant.
Judge, I think at this time we would object to the purposeful killing language in that particular preliminary instruction. I think I indicate to the court that we have in front of us, and we can mark as an exhibit what Mr. Pardon was, in fact, having sentencing entry, and I believe it's been marked already.
Yes,
DD.
State's Exhibit D, David.
And I believe it indicates that what Mr. Pardon was actually convicted of. So if the jury wants to consider that prior conviction, they should consider it for what it was, for that specification. And it was not murder, it was an attempt murder.
Okay, thank you. Well, if the jurors are to consider it, they're going to have State's Exhibit DD, which would indicate exactly what Mr. Pardon had previously been convicted of. The language that the court is going to provide to the jurors in the preliminary jury instructions mimics the language of the statute, and then likewise would mimic the language that the court will ultimately provide to the jurors in its final instructions when it provides to the jurors each of the specifications for their consideration during deliberations. So the request to delete the language is overruled. Noted for the record. Okay, with respect to the verdict forms, any objection on behalf of the state?
No, the verdict forms presented to the state, there is no objection to, Your Honor.
Okay. On behalf of
3 as to each count, and they meet the state's approval.
No objection.
Okay.
We had opportunity to review. We have no objection.
All right, thank you. Okay, there was also some other discussion with respect to the PowerPoint that would be presented by Dr. Stenson. Is there anything that the state would like to place on the record regarding that?
The state will cross-examine the witness with respect to its appearance in this case rather than seek its exclusion, even though we first saw it this morning.
Okay. Or seek a continuance, because that was one of the options that was discussed.
Correct, Your Honor.
Okay. The state had indicated that it was not inclined to request a continuance. All right. Anything on the record with respect to Stenson's report that you want to place?
Not at this time.
Okay. Was there anything else that the state wishes to place on the record with respect to any of the information that would be provided in mitigation?
No, Your Honor.
All right. Okay. And then anything else on behalf of the state? I'm going to say on behalf of the defendant. I don't know if you want to place on the record anything with respect to the potential witness, I guess, that appeared today.
Yes, ma'am.
Yeah.
Your Honor, not at this time.
Okay.
Judge, I think we'll take advantage of the lunch opportunity, put one other item on, but not at this time.
Okay. All right. Are there any other matters then that we need to place on the record at this time before bringing the jurors in?
No, Your Honor, not from the state.
On behalf of the defendant?
No, Your Honor.
All right. Thank you. All right. Mrs. Harper.